Chairman Kiley and Ranking Member Bonamici, thank you for the opportunity to testify today. My name is Don Daugherty, and I'm Senior Litigation Counsel for the Defense of Freedom Institute. In my time, I'm going to focus on the implications of Mahmoud v. Taylor going forward. Parents of faith will be able to use Mahmoud to push back against overreach by public schools, and the case should lead to more curriculum transparency. For example, now in Montgomery County, each semester students receive refrigerator magnets detailing the upcoming curriculum, including books to be read so that their parents can decide whether they want to opt out or not. Also, another case in late December in Massachusetts, a federal court there relied on Mahmoud to enjoin Lexington public schools when the schools refused to allow parents to opt their 5-year-old out of LGBTQ-themed books that violated the family's Christian faith. So that's just a very recent case. At the same time, Mahmoud is not a license for parents to micromanage the curriculum, and courts will need to define more clearly what this free exercise parental right encompasses. Some parents in Mahmoud objected to the storybook series on purely secular grounds, and the Supreme Court has recognized that under the Due Process Clause of the 14th Amendment, that is apart from the Free Exercise Clause of the First Amendment, parents have a substantive right to direct the upbringing and education of their children generally, not just in matters of religion. Guidance from the federal courts will be needed on this issue as well going forward. Finally, a mystery surrounding Mahmoud is what critical principle was the Montgomery County Board of Education trying to vindicate by defending its no opt-out policy all the way to the Supreme Court. Many people wondered about this. In addition to Montgomery County families, many Montgomery County principals and teachers in public schools questioned the use of the storybook series. Before the case was decided, the Washington Post and the New York Times criticized the board's decision to force parents to go to court, and the board expended considerable taxpayer dollars fighting those parents when they could have easily reached, I believe, an out-of-court settlement. During oral argument at the Supreme Court, Justice Kavanaugh, who pointed out that he is a lifelong resident of Montgomery County, he stated that he was a bit mystified how it came to this, noting that Maryland was founded on religious liberty and expressing surprise that the board had decided that this is the hill we're going to die on. Justice Alito similarly asked the board's attorney, what's the big deal about allowing parents to opt their children out? And even Justice Elena Kagan, who ultimately dissented, said she suspected that there were a lot of non-religious parents who weren't all that thrilled about this. Although no one can read the board's minds as to what they hope to achieve through this case, at the least Mahmoud did reveal how disconnected some public schools have become from the families that they serve. The First Amendment and the Bill of Rights generally exist to protect individual rights from a tyranny of the majority. As public schools more and more encroach on aspects of a children's upbringing beyond the core curriculum, the importance of constitutional bulwarks only increases. In Mahmoud, the Supreme Court wisely reinforced the free exercise bulwark. At the same time, parents cannot allow themselves to be treated like a captive audience by their elected representatives. Mahmoud shows that parents can and must take back their children's public schools, and that the First Amendment is one way to assist them in doing so. Thank you.